Well, good afternoon, everybody, and a warm welcome to today's NEC webinar on the October 2020 amendments to the NEC 4 suite of contracts. I'm Patrick Waterhouse, and with my colleague David Hunter, we will be taking you through the changes to the NEC contracts over the next hour or so. I've just put in the chat function that we hope to have time for some questions at the end. We'd be grateful if you didn't interrupt whilst we are speaking. But as I say, we hope to have plenty of time at the end for questions. So if you do have any, please put them in the chat function, and David and I will try and pick them up at the end. So, who's talking to you today? Well, I'm Patrick. I'm introducing this. I'm alongside David Hunter. David, you can see his credentials at the top there. David, like me, is an NEC Contracts Specialist. He's an NEC consultant and trainer. He works on the Project Management Accreditation Program for NEC, and he also is an assessor and marks the papers, as do I. In addition to that, I'm a construction adjudicator. I deal with most matters of construction disputes, particularly those involving NEC, and I have also had a number of books published, including a couple of them on NEC 4 contracts, with a third on its way. So a bit of domestics and housekeeping for you this afternoon. Please, if you want to listen, and we assume you do, audio will come through your computer, not through any other route. Please disable your microphone and your webcam, and any questions you have, please put in the meeting chat, which you can access through the speech bubble you can see on your menu bar in Teams. We are being recorded today, so please bear that in mind. A recording will be made available to you at a later stage, and we've just seen the question and answer appear in the chat function that the presentation slides, the PowerPoint file, will be made available to each of you after we've finished today. And also we have an engagement app we're using today, Vivox or Vevox, and there will be 6 polls that we will be undertaking today, just to establish who is from where in this industry, what experience you've got of these issues and what you think. You can either download the app from your app store, or if you just click on the link following vivox.app, you'll find that you'll be able to do this on the web. The ID is the one you can see there, so take a minute to write that down. Despite our finest attempts with the leading ICT practitioners in the world of NEC contracts, we have not managed to change the name of the poll. So once you get to the poll of that ID, it has some imaginative title like Test 1 or something like that, but be assured you're in the right place when you get there. So we'll just leave that slide up for another few seconds so you get the chance to write those details down or to use them. Okay, so what will we be discussing today? Well, as a slight history lesson, NEC 4 is almost 4 years old. NEC contracts are still described by some people as relatively new. The first consultative edition came out in '91, but NEC 4 is extremely new in the eyes of some people, yet we've had it for 4 years now. And there have been 2 sets of amendments to it since it was first published in January 2019 and most recently in October 2020. And the amendments that were made, David and I are going to take you through today, were made for a number of reasons. Some of it was due to changes in law caused by case law. Some of it was just merely taking the opportunity to tidy things up that, based on early experience of the NEC 4 contracts, we had found didn't work as well as it could do. So there were changes to secondary option X7, delay damages or liquidated damages for late completion. Changes to YUK2, which are the additional clauses needed to make NEC contracts comply with the Housing Grants Construction and Regeneration Act in Great Britain and with the Construction Contracts Order in Northern Ireland. There are changes to secondary option X22, which are the early contractor involvement provisions for NEC. Previously, they were published as a separate document, and NEC 4 for the first time they were brought in as a secondary option as X22. There are changes to, in certain forms, the contractor's liabilities for equipment and equipment. Now, you may ask, equipment and equipment, why have they said that twice? Well, you can see there, if you pay careful attention, one of those equipments has a capital E, the other does not, and they mean different things, and we will explain that to you when we get to it. As part of those changes, there were also changes to the clauses about the contractor's use of equipment with a small e. And finally, in this list, there were changes to clause YUK1, which is the project bank account provisions for use with NEC contracts. So our first poll, for those of you who've worked out how to do all of this malarkey, which party do you normally represent or work for or act for? Is it 1, the client or the employer? Number 2, the contractor or the subcontractor? Number 3, as a consultant, maybe as a project manager, as a cost management consultant, as an engineer? Or number 4, if our admission criteria for this event hasn't been too strict, have we actually got any lawyers with us? So could you now select 1, 2, 3 or 4?
Patrick, I don't know if you can see this on your screen, but I'm seeing responses come through, and we've got 20 plus people on the session today, and I have 21 responses, so I'm going to close the poll.
Excellent, well done. I get an indication of the numbers involved, and here we are. Oh, crikey. So most of you are either clients or consultants. We have a few contractors and lawyers in the audience. Very good. So welcome to you all, even to the lawyers. Thank you. Right, David, let's move on. So the changes to the suite of contracts, as I mentioned a few minutes ago, the NEC 4 suite was launched in June 2017. There were some amendments in 2019, which were primarily about the compensation event provisions for delays to completion date and key dates, but also took the opportunity to tidy up a few areas that needed improvement in terms of the drafting and the spelling. Then the amendments we're talking about today came out in October 2020. All of these amendments are available on the NEC website for free, but you do actually need a copy of the original document if you're to see how they work. And finally, a note that we're well aware that NEC 3 is still in widespread use across the industry. We know that many organisations are slow to change such things because of the cost of drafting new documents, training staff and so on, and also because in a number of places NEC contracts are used in long-term frameworks that were procured some time ago with NEC 3 specifically mentioned in the procurement notices in OJU, and therefore there's a reluctance to change those on those frameworks until they expire. But NEC has publicly stated it will not be updating NEC 3 contracts. Updates to the contracts will only be provided now for NEC 4 going forward. So if you are using NEC 3 contracts, contracts, it may be a good idea to look at the amendments that are being done with NEC 4. And I can't emphasize the next bit enough. Find somebody who knows what they're doing to draft you amendments to use with NEC 3 contracts if you're still going to use them. But obviously, I think the simplest thing you could do would be to switch to NEC 4 contracts as soon as you can. And now I think I'm going to hand over to David to talk about, firstly, which contract am I looking at?
Thank you, Patrick, for that excellent introduction and setting the scene for us for the rest of today's session. So yeah, how do I know which version of the contract I am looking at? And on the face of things, the question we're asking may seem a little odd. However, if you're looking at the book, the contract, and the front cover, the answer to that question is not, in fact, readily obvious. In fact, on the bottom right-hand corner of the book, front page, you will see it says June 2017. However, if one is to open up the contract, you will see fairly early on that the reference to the amendments October 2020, beg your pardon, is stated. A little further on into the October 2020 version, there is a short summary of the amendments, both for those that came in January in 2019 and October 2020, which is what we're looking at today. As Patrick said, if you want more detail on those changes, over and above, of course, attending this session, the detail is available on the NEC website. Now, in terms of the parties understanding which version of the contract you're working to, we turn to contract data. And we have a statement here in the very first part of contract data part 1, which is the client section. And you can see it's underlined there, NEC 4 engineering construction contract, June 2017, in brackets, with amendments October 2020. And just to clarify or confirm that if that's the contract version you are using, that also incorporates the changes and amendments that were made in Jan 2019. Yeah, we see some questions coming through on the chat, and Patrick has kindly just said that we'll be answering those towards the end of the session. So we'll be keeping an eye on those, and in whatever time we have left, we'll try and deal with those. So yeah, great to have some questions coming in, and we'll look at those towards the end. Right, going to start with another question of the poll. We'll just click on here and get it moving. So you should come and see that now in the app. Really just to gauge where we are with users in the NEC 4 version. Have you been involved in the project using NEC 4 contract? Simple yes, no, or no, but will be the next 6 to 12 months. And just pause for the responses to come in. Got quite a few coming in, 24 out of 31. Moment just to allow others to register their vote. Excellent. Okay. Thank you for getting involved in this. It's good to get some interaction and see what the position is. Now, closing the poll, and let's have a look. Interesting. So 65%, that's almost 2/3 of you now using NEC 4 contracts. 19% no, but 15 that says no will be in the next 6 to 12 months. So yeah, I think we can say that at this point, NEC 4 really is starting to take hold, and perhaps after a slightly slow start, we're starting to see most users now engaging with one of the 16 forms in the new suite. Excellent. Okay, so we're starting with looking at delay damages, secondary option X7, and first to identify which of the forms of the contract are affected by the changes. We have the ECC, it's the main form and the subcontract version, the professional service contract and its counterpart subcontract, and also the supply contract. Now, we also see delay damages used in the term service contracts and the short forms, but we don't have an equivalent X7 clause. Delay damages for the term service contract are applied or used for task orders. Core clause 19 now bringing in task orders include for delay damages. So it's clause 19.7 that is affected. And for the short form contracts, where we see delay damages, the statement is not a secondary option, but part of the core clauses, clause 50.6. So pretty much most of the contracts will be affected by this. So next poll, have you been involved in a contract where delay damages were applied? 1 for yes, 2 for no. No, but I might be soon. Have you been involved in a contract where delay damages were applied? Excellent. Well, it seems to be working very well, actually. I think it's certainly the second time out that we've been using this technology, the Vivox app. And I've seen 33 responses out of 33, which is excellent. So let's see what the results are. Ooh. 55% have said yes. That is a higher proportion than I would have imagined, but interesting. 40% have said no, and 6% seem to be thinking they got a contract where they might be soon. So yeah, I suppose if we add the 54 to the 6, that's 60%. It's getting on for 2/3 where delay damages may be or will be applied. So what we've got to talk about will be of interest to you. Before looking at the October 2020 version of the clause, it's worth just reflecting on what the current version says. So I'm looking at the ECC today, it's simpler. The January 19 version, X7.1, the contractor pays delay damages at the rate stated in the contract date from the completion date for each day until the earlier of completion and the date on which the client takes over the work. So delay damage is applied up until completion is achieved or when the client takes over the works. So that's what January 2019 version looks like. And the change for October 2020 now includes a third bullet point, and the change is underlined. And we're now looking at considering not only completion and takeover of the works, but also the position when the project manager issues a termination certificate. So it's the earlier of those 3 situations. So what does this mean? Well, the first thing it means is that in accordance with the revised X7.1 clause, the contractor will be liable for delay damages and those damages that are accrued up until the point of termination. So we have some clarity there. But those liquidated damages or delay damages, as the NEC calls them, will cease on termination or cease at the point at which the project manager has issued a termination certificate. A third bullet point on the slide here is a question that we're leaving open, really, and we'll consider the reason for the X 7.1 change, which may give some light to this. But the question may still be remain as to whether the contractor may be liable for general damages or costs in this situation. So what are the reasons for the change? Well, first of all, I suppose maybe we've got a greater sense of clarity now in the situation and the position where termination of the contractor's obligation to provide the works has been exercised. And the motivation for this comes from a case that had a lot of attention, let's say, legal commentary, and it follows a sort of over a century of various judgments over the last 100 years or so, each with varying results and possibly even conflicting judgments. And things came to a head in 2019, in March, where, and this is the case you may be familiar with, Triple Point Technology Inc. and PTT Public Co Limited. This was a hearing in the Court of Appeal. Now, Triple Point Technology and PTT is not a construction case, but it is of interest to us. Triple Point is a designer of software for commodities trading, and PTT being a company actually engaged in those trading commodities, gas, oil, etc., based in Thailand. The contract included payment milestones with liquidated damages for late delivery up until the point when PTT would accept work. Cut a long story short, the project got into delay. PTT stopped paying Triple Point, and Triple Point also then stopped work. PTT terminated the contract, and then Triple Point sued for non-payment. There was a counterclaim that came from PTT, and that was for damages, including liquidated damages, to the tune of $3.5 million US. As this was heard in the Court of Appeal, of course, there was a first instance case, 2017. The case was heard in the TCC, but Triple Point's claim for damages, liquidated damages, was dismissed. And PTT was awarded the $3.5 million. There was the appeal, and the Court of Appeal was in March, as I say, 2019. Cut a long story short with this, there was reliance on a case from 1913, British Glanstoff, and up until Triple Point, it was generally accepted that the damages, liquidated damages, were recoverable up until termination. However, looking back at the Glanstoff case, which had not previously been cited, the Court of Appeal suggested that damages would, in fact, anything accrued before termination would fall away in the event of termination. Now, the story hasn't ended here, because the case was heard again by the Supreme Court, and that appeal was heard in November, back end of last year, and we're still waiting judgment on that. So next poll, just to look at position of termination, because this question that we face with under X 7.1, the change is a combination of matters associated with termination and delay damages. So open the poll here. Have you been involved in a contract where the contractor's role was terminated before completion and the contractor was responsible for the delay? So answers coming in pretty rapidly, which is good. Just wait a few more moments for final few people to present their answer. Excellent. Okay, let's close the poll and see what we've got. This should be interesting. Well, there you go. A resounding no, more or less. It could be interesting to speak to the people that have said yes. 81%, 82% said no. 6% might be soon. Okay. Moving to the next amendment, we're looking at YUK2. So those of you familiar with NEC contracts will know that the YUK2 clause is written in response to the requirements of the Housing Grants Construction and Regeneration Act, and particularly in respect of payment. The clauses or the contracts that are affected are the professional service contract and its counterpart subcontract, the term service contract and also its subcontract, and also the design, build and operate contract, which a new form for the NEC 4 suite. Now, why are not all of the contract forms affected? Well, the reason being, in particular, if you look at the ECC, the engineering construction contract, and the supply contract, these are not affected because neither of these forms include provision for invoicing in the payment process. And the short forms are also not affected, specifically, even though they have invoicing, the reason being that the short forms, the invoice is the trigger for the payment process, which is our pay-led, and not dependent on a payment certificate. So before we look at the change that's made to Y2.2, which is the clause that we're interested in, it's worth just having a look at the position under the current version. Now I'm going to refer to the term service contract here, just for convenience. I'm going to do a timeline, which is a lot easier to explain because looking at the words, it's not quite so easy. So a picture hopefully paints 1,000 words, and we've got some fly-ins, so we'll provide a little commentary over that and see how we get on. Payment timeline starts with the assessment date, and within 1 week of the assessment date, we find ourselves at the due date for payment. Now, in following the contract, the requirement under NEC 4 is the contractor's application for payment must be made before the assessment date, and the service manager has the responsibility of assessing the amount due and producing a certificate of payment, what is known as the payment notice, or notice of payment in Construction Act terminology. 7 days after, the contractor is required to provide an invoice within 7 days of the service manager's certificate. And the final date for payment is then determined by the later of two things. The first is 14 days after the due date, but then 7 days after the contractor's invoice. So the later of those two events. So we can see that the contractor's invoice is going to be dependent upon the service manager's certificate, known as a payment, and then the final date for payment then linked or pegged to the point at which the contractor has submitted their invoice. Just to complete the process here, our payment process, we have a pay less notice, 7 days required before the final date for payment, client's pay less notice. So we shall now turn to the October 2020 amendments, and we'll go through the timeline again. You can see the difference that we've got. Start the assessment date as before. Also, contractor's application for payment is required before the assessment date, and the service manager certificate again still required within 1 week of the assessment date. We now, however, have the contractor's invoice submitted within 1 week of the service manager's certificate, and it's the due date that now is determined by the later of 14 days after the assessment date and the date of receipt of the contractor's invoice. So we're looking at the due date now being triggered by the later of those two events. You have to go into the core clauses to see the obligation on the contractor to submit an invoice, and it's clause 51.1, and just got a little asterisk at the bottom there, to submit within 1 week of the service manager's certificate. And then the final date for payment is 7 days after the due date. And these terms we've got here are the standard periods that NEC4 give. If you want to do something different, then you have to put a separate contract data entry in part 1. So the final date for payment is now pegged to the due date by a fixed period of time, in this case 7 days. Finish the story off then. The pay less notice here again is unchanged in terms of the time period, but 7 days before the final date for payment. So what was the reason for the change? Well, we had this case last year, Rochford Construction Limited and Killen Construction, which there was a dispute over payment, aren't they all? And one of the arguments advanced by Killen, or by the legal team, was that if looking closely at the Housing Grants Construction and Regeneration Act, in particular section 110 brackets 1 brackets B, that the Construction Act said that the final date for payment should be linked to the due date by a fixed time period, and not an event that's controlled by one of the parties. So, for example, a payment notice or an invoice. Now, in advancing the legal argument, it was a reference was made in contrast to another part of the Construction Act, section 110 brackets 1A, which does require an adequate payment for determining, adequate mechanism for determining what payments become due under the contract and when, so for the due date. Now, the court agreed with the argument, but the position held by the court and the views expressed were obiter, so perhaps persuasive only, but perhaps strongly persuasive, but that yes, the final date has to be pegged to the due date and be set a period of time, not an event or mechanism. So this decision was in the TCC, Courts of England and Wales, and a reminder, of course, that the Construction Act also includes Scotland, and there is similar legislation in Northern Ireland. Now moving to secondary option X22, early contractor involvement, ECI. Now Patrick did give a brief overview of the history of ECI in the context of NEC. The ECC has X22 as a secondary option now, but also the alliance contract. My focus, or our focus today, will be looking at the ECC. A quick recap on X22 as it is described in the ECC. For those that aren't familiar, essentially it's provides you with a single contract with 2 stages. First stage being a period of early contractor engagement, ECI, and the second stage for construction. NEC4, I think X22 is also newish really for the contract, albeit that the ECI clause has been around since January 2016. If you wanted to use it with NEC3 and before the 4th generation of contracts was issued, then you'd have to put that in as a Z clause. But the clause itself largely unchanged since January 2016. So after I think some user feedback and people starting to get more confident and more accessibility to use the ECI clause X22, some changes were made. Feedback was made. Before we go into that, just get some feedback as to whether people are actually now using X22 with their contracts. So just open the polling there. Simple question: have you been involved in an NEC4 ECC contract using X22? So a simple yes, no, or no, but I will be in the next 6 to 12 months. Just a moment, pause there for the last couple of responses to come in. Looks like we've got the majority of them. Excellent, so thank you for that. We'll close the polling and see what you've given us. Interesting. So over a third of you are saying that you are using it or have used it. Another 16–17% say no, but we are looking to use it in the foreseeable future. But almost half saying they haven't used it. Okay. So what are the principles behind the changes that we see in X22? Generally, to give us a more flexible approach to certainly the stage 1 part of the ECI phase, but also embed more of a structured process in the submissions that the contractor makes during stage 1, and also tie that into the notice to proceed, if indeed notice to proceed is given to stage 2. So what we see now is an introduction that during the stage 1 period, the changes can be made also to things that are related to program, essentially. So access dates, key dates, and also the completion date. And the process for this is that the contractor would submit proposals to the project manager and do so on the conclusion of stage 1. And because of the changes to the program, you also got the requirement to issue a revised program, and also any changes to the total of prices, or indeed, if you haven't agreed the total of prices at the beginning of the ECI stage, what they in fact are before you enter into stage 2. So before the notice to proceed to stage 2 is given, because of these additional requirements, we've got the need for the contractor and PM to agree on what the position is regarding the target, the total of the prices, and those changes that may be made to the program aspects of the contract, so access dates, key dates and completion date, and of course also the revised program. Okay, so at this point here, I'm now going to hand back to Patrick. Patrick's going to take us through the remainder of the session, starting with looking at contractors' liabilities.
Right, thanks very much, David. So we start, as David said, with contractors' liabilities. For those of you who have been revising and you're familiar with your colour scheme, we're going to talk about the term service contract, the grey one, and the design, build and operate contract, the blue one. There's a colour for everything in Planet NEC. So liabilities, you will remember, replaced what previously were called risks in the NEC 3 and 2 versions of the contract. And here there's been a bit of tidying up going on in the contract. It applies to 3 of the suite, the term service contract, the term service subcontract, which largely matches the earlier one, and the design, build and operate contract. And the detailed clause reference is there. And this recognises that I think the drafting was capable of improvement, should we say, having got rid of the reference to risks from NEC 3, which I think was an excellent choice by the NEC drafting panel when they did it. The word liability is now used. There are clients' liabilities where previously there were employers' risks, and there are now contractors' liabilities where previously there were contractors' risks. So what did the document say before we played around with it? Well, you can see here the following are contractors' liabilities. This is clause 81.1, which follows clause 80, which sets out the client's liabilities. And one of them is this one: loss of or damage to any plant and materials before they are included in the affected property and equipment. Now, plant and materials, you'll remember, are things that the contractor provides and incorporates into the affected property when it does something. The affected property, another defined term, is the infrastructure or the assets the contractor is responsible for providing a service to. And the word equipment, defined across most of the NEC suite of contracts, are things that the contractor uses to provide the service in this situation. And I think you'll agree, if you read that second bullet point there, there could potentially be an argument about how it's interpreted, particularly the reference to and equipment at the end. So if we move on and we can see what's been changed to it, you can see now that the clause has been separated out into some sub-bullets. We now talk about loss of or damage to any plant and materials before they are included in the affected property. So the contractor may have purchased plant and materials that they're going to bring to the property in a building. That could be air handling units, it could be a new boiler, electrical switchgear, cabling, anything like that. And if it's damaged somewhere away from the affected property, it's not yet been included into the affected property, then that is a liability for the contractor. Presumably, unless it's a trivial amount, it will be an insurance event anyway. Loss of or damage to equipment, remembering that equipment is used by the contractor, provided by the contractor to enable it to provide the service, and you wouldn't expect the liability in the loss of that or the damage to it to be anything other than resting with the contractor. And then finally, the new item, oops, sorry, we've just jumped there. Thank you. Equipment, lowercase e, provided by the client to the contractor. So why have we got 2 uses of the word equipment? Well, equipment with a capital E, defined, something provided by the contractor. Equipment with lowercase e is not defined, and therefore in the normal rules of contractual interpretation, it has its ordinary meaning. And in this situation, it's further clarified by saying equipment provided by the client to the contractor. Now, remember that in a lot of service contracts, the contractor is there for a defined period of time. It may be 1 year, it may be 4 years, 5 years, it could be longer. And sometimes with particular assets, you have particular pieces of equipment that may be unique, may be bespoke to the infrastructure in question, such as a window cleaner's cradle on a tall building or something of that nature. And therefore, the client will sometimes provide equipment to the contractor. It will be mentioned in the contract that we are providing you with this, but clearly once it becomes under the control and the care of the contractor, it becomes the responsibility of the contractor. And if it says loss of or damage, I'm not sure how you could lose a cleaning cradle, but you could potentially damage it. That is a contractor's liability. So it's important to look also at the client's liability here. Loss of or damage to equipment, lowercase e, and plant and materials supplied to the contractor by the client or by others on the client's behalf until the contractor has received and accepted them. So that is the client being responsible there for these things, equipment and plant and materials, before they are passed to the contractor. So why have we changed this? Well, it's been changed partly to tidy it up. I don't think the original version of the clause read particularly well, and for those of you who, like me, deal with contract disputes, you'll know that the moment there's a weakness in any particular word, clause, or part of the contract, it will become an issue between the parties if it's relevant. So obviously we want to make sure that a standard form of contract is actually capable of clear interpretation and avoid that situation. So it's making clear here that the contractor will be liable for the loss of or damage to equipment provided by the client. Remembering that equipment and equipment, as it says there in the third bullet, are not the same things. And you'll see in the final bullet there that the word equipment appears in a number of places in the term service contract and term service subcontract. Now, related to this is also changes to references to the contractor's use of equipment and material. These clauses affect the same three contracts we've just looked at, and it's the term service contract, the term service subcontract, and the design, build and operate contract. So here's what clauses 71 and 72 said in the original version of the NEC 4 term service contract. That in clause 71, the contractor has the right to use equipment, small e, plant and materials provided by the client only to provide the service. So any of these things that the client provides to the contractor can only be used here on this contract to provide this service. So if there is a vehicle, or there's some construction materials perhaps that are provided by the client, then they are for this service only, and without the consent of the client they can't actually be taken somewhere else. Secondly, in clause 72, it said that the contractor has the right to use material, and this is lowercase m, I'll come back to that in a minute, provided by the client only to provide the service. And the contractor may make this right available to a subcontractor. Well, the word material isn't defined here, and it's frequently been taken by users of the contract to mean intellectual property material. But in reading what some of my very well qualified friends at Keating on NEC 3 have said about material, they say that the use of the word material, because it isn't defined, is a very broad one, and it can effectively mean anything that the parties, that the client has provided to the contractor to use on this service. Now, of course, the issue of intellectual property has been thrust into the mainstream news this week. For those of you who buy your children's party cakes either from Marks and Spencer or Aldi, you'll know just how upset some people can get when intellectual property is potentially used somewhere where it allegedly isn't licensed to be used. And in the business we work in, intellectual property is never far away from what is being provided by the parties. As I say, better legal minds than mine have suggested that the use of the word material with a small m can actually refer to a very broad range of things. They may be physical things as well as knowledge things. And I've just been reminded by Ross Hayes, who's on this call at the moment and is one of the key figures behind the NEC's FM contracts that have been published recently, that all of these changes are included already in the right places. And I think a lot of these will be very useful in the FM contract side of term service provision. So what does the new version or what do the amendments say here? So the contractor has the right to use equipment, pause, so that's equipment not provided by the contractor, so that will be something provided by the client. Plant and materials, which I think is a phrase it's defined, we understand it quite well, and other material provided by the client only to provide the service. So this other material, be it physical or be it intellectual, can only be used to provide the service if the client has issued it to the contractor. The ability of the contractor to make a right available to a subcontractor is important, because where specialist work is subcontracted, the people doing that work will need access to either the physical material or to the intellectual material. And you'll see there, for instance, it's a subcontractor with a capital S. So it is one of those organizations that's defined in the contract, and one of those organizations that has to be accepted by the service manager before it is appointed to do something. So 72.1 has gone, and the reason for the change is to simplify the clause. It didn't read particularly well before. I think it does it much better now. So we now move on to project bank accounts, and project bank accounts have been around for a while. But they first got printed into the NEC documents, if we call it that, back in 2013, I think it was, when the NEC 3.5 suite was published, and they came in as YUK1, and they exist in all of the what you might call full NEC contracts, so not the short forms, and also with the exception of the design, build and operate contract. There have been a small number of drafting changes. They're largely based around tidying things up and around the changes in banking service provision since. Partly the users group and the drafting panel have looked at user feedback. There are different features of electronic banking now, particularly the remote access, the automatic direct feeds you can get from bank accounts now. And we've also tried to look at the latest best practice. There is now a choice of an account holder. You can see there it's written in italics. So in other words, it's identified in the contract data. It can be contractor, it can be client. And because of electronic banking, the provision and the maintenance of these two documents should be relatively straightforward now. So if I can ask Professor Whitty to switch over to the next slide, please. Thank you. The payment schedule is prepared by the contractor, and this based on what most people have as a monthly payment run. We have a payment schedule prepared by the contractor, copied to, depending which contract you're in, the project manager, the service manager, the supply manager, and is sent to the project bank. Project bank, you'll see there in italics, identified in the contract data, and then the payments are authorized based on what's on the payment schedule. And the payment schedule very simply will say how much money is going to which organisation out of the account. The project bank account tracker, and this is where I suspect that electronic feeds from the banking system will facilitate this very easily. First of all, has to be in the form stated in the scope. So a classic NEC type statement for you that the document that we want the contractor to produce will be set out in the scope. So there is another tick in the box you need to do at contract formation stage or at tender stage. You'll be aware that within the user guides for the NEC contracts, there is advice on how to draft the scope. Included within that are the necessary items you must have in the scope based on their direct reference in the clauses of the contract. And here's another one for you, the PBAT, or the Project Bank Account Tracker, which is a bit of a mouthful, and it's an ongoing document that throughout the contract, which is a register of all of the payments made into the project bank account by the client and all of the payments that are then made from the project bank account to the various recipients. And the contractor has a timed obligation to update that within 1 week of the payments being made. So there is a live tracker at any time showing what's gone in and what's gone out. So here we are with another question for you. And of course, you know, you've got to answer within 8 weeks, otherwise your vote will not count. So I'm looking at my phone, I'm going to do it myself. Have you been involved in an NEC contract since 2013 that used a project bank account? And if so, was YUK1 used? There you go. I've clicked yes, but with major amendments.
I don't know if you can see the responses on your screen, Patrick, but I'm now seeing that 30 out of 31 have responded, or 30 out of 32, or 31 now.
Yep.
So we'll close and see what the audience think.
So a whacking great 64% of you have never used project bank accounts with an NEC contract, and the rest of us have used them, but in a variety of different ways, which doesn't surprise me in the slightest. And you may be aware that a certain number of major clients in the industry make project bank accounts mandatory, and in other places some people do it on a case-by-case basis. I personally think it's a vastly underused way of supporting the supply chain with decent cash flow, and also with protecting the supply chain in the event of an insolvency. Then people don't lose all of the money due to them for the last 2 or 3 months. So that, I think that's possibly the final vote and the final slide. So that's pretty good. David and I were aiming at 1 hour long. We've fallen 2 minutes short of our hour, and we've had a few questions come into the chat function, and I think one of the first ones was from Graham Sutherland, who was asking, have there been any changes in law which the latest version of NEC 3 will not cover or will conflict with? Well, the answer to that, Graham, if I can start off, very clearly is possibly. We explained how the triple point case had led to the need to change certain things. I'm not aware of any changes in statute in England and Wales that would necessarily cause a problem with the NEC 3 form, but remember that was published now 8 years ago, and if you want to keep using a historical form, I think you need to make sure that you at least have somebody who A, understands the law, and B, quite importantly, understands that contract to at least give it the once over before you decide to use it in the future. I don't know if you want to add to that, David.
Yeah, I think, I mean, Graham's question came on very early in the session. It's a good question. But as we went through things, hopefully Graham's seen that some of these changes have been because of judgments and change in the law, certainly change in the law that have been made through the courts. A wider thing, which is probably another session in itself, of course, is that changes to legislation is also something that we have to concern ourselves with, and the change to the Coronavirus Act and COVID-19, that itself has probably spawned quite a few Z clauses, but of course the contract doesn't specifically deal with that. So yeah, hopefully Graham, you've got a reasonable answer to that question.
We had a second question from Judith Woodward, who was talking about a term service contract awarded between a county council and a contractor, where the county council wanted to instruct a task order for the contractor to do something in contract with a district council, with a third-party organisation, and the advice, if you call it that I gave in the chat function was that the TSC didn't anticipate the role of a third party in a task order. Notwithstanding that, it might be you could agree a direct agreement between the three organisations in question, but the TSC very clearly has two parties to it, and I think you'd need some good Z clauses if you wanted to amend it to include a third party.
Yeah, I mean, I think we'd say that apart from the alliance contract, all of the NEC4 suite are predicated on a bi-party agreement. So yeah, tread very carefully, I would say.
Right, I'm just flicking through the questions now. So David Aranda said that X22 was swiftly explained. Indeed it was. We've got an hour to get several important subjects across, so they were swiftly explained. I would appreciate it if you could briefly come back to this clause. Well, I don't know which bit of it you want explaining again, David. If you want to drop into the chat function any specifics that you want covering again, but we may have time to look at those.
I guess sorry, Patrick, I guess
yep,
for David's question, whether he's looking more at a wider understanding and knowledge of X22 rather than just the change itself. Is David still with us? I don't know. We can get people on microphone here if they want to talk for some of these specific subjects. I know it's difficult sometimes to express questions in a sort of soundbite way through the chat box. David does say the main change briefly, thanks. David, come on microphone, because I'm not quite sure what you're looking for here.
I thank you very much for this presentation. Thank you, David. Thank you, Patrick. Basically, the X22, which is now a very, very hot topic on the industry. You flick quite quickly the slide when explaining the change on the X22. I think I will welcome, as well as perhaps others on the call will welcome, if you could briefly revisit what the change is from 2019 to now, basically.
Sure. Okay, David.
I'm happy to go through the slides on my own time afterwards, but I think will be useful briefly. Thank
yes,
you.
no, David, I respond. I think one of the things about the X22 as it was drafted before the October 22 amendments was around program. Now, the idea, of course, is in stage one of the contract, which is the ECI, the early engagement phase. There's always a question of what can we actually agree before we start, and depending on the extent to which the client has progressed their requirements, the scope, and in fact even their design, will dictate whether or not the contractor can realistically put a price or even a program to the tender. Now, X22, as a reminder, is the secondary clause, which is only available and based on use with option C, so a target contract using an activity schedule, or an option E, cost reimbursable, cost plus contract. And in the previous version, before the change, there was little or no flexibility for the parties to actually change the completion date after they've entered into the contract for stage one, which, of course, when you think about it, it's the one thing that is most likely to be you need to change, given that as you go through the stage one, the development of the scope, the design, time and money, program and cost are the things that are going to change and react to that development through the ECI stage. And associated with completion date and matters of program, we have key dates and access date. So you see now that there's an ability to change those, let's call them milestones, through the ECI phase one or stage one, but then we freeze them at the end of stage one before we enter into stage two, the construction phase, on the notice to proceed that the project manager gives once the client has accepted that it can go forward. So more flexibility in really managing the program aspects of of a project or a contract, which are very likely to be subject to fluctuation as you develop that the detail of your contract, of your project. Does that help, David?
Thank you very much indeed. Very good explanation. Thank you very much, and I really welcome your time and your clarification. Thank you. And
thank you very much for your question.
Okay, there's a few more questions appeared, and I think there's a couple of them I can probably deal with promptly. So Chris Mackay has asked, how often do folks see W1.41 deleted so that adjudication is not compulsory? For me, never. If you are working on a contract where the Housing Grants Act or the Construction Contract Order do not apply, and therefore adjudication is not required as a matter of statute, then the parties can quite happily agree that adjudication doesn't form any part of the contract and that any subsequent claims would only be dealt with through litigation. But the answer to the question is never. Then we had an interesting one.
Patrick, before you proceed,
yep.
Sorry, Patrick, sorry to interrupt your flow. Quite interestingly enough, and very recently, I have been working with a client where the Construction Act doesn't apply, so we're not minded to use or apply option W2. And naturally, when you're looking at the options, W1 is what you would defer to. However, and it is it's the first time I've seen it, and it is, I think, a real exception to the rule, that the client has decided that they don't want to use adjudication and at all, and it's not compulsory. So I think it's very rare, but you do see these changes from time to time.
You do, and depending what your contracting policy is, if you're a big, well-funded organisation and your contractual partners are not well-funded, then adjudication provides them with a cheaper route to pursue disputes against you, and if you remove it, it makes it a much more expensive exercise if they ever want to enforce something against you. Now, a personal interest I've got here, Stephen Knox has asked, apologies for asking a question slightly out of the scope of the webinar, but why in the 2019 changes to the professional service short contract was the list of key persons added, because it wasn't originally in there? Simple answer there, Stephen, is the proofreading in the first round of the NEC 4 contracts missed the omission. It wasn't a conscious decision to leave the key persons out of the contract data, and the bloke that was paid to do the proofreading missed it back in 2017, so it was put back in 2019. So that's the simple answer to that question. And a more relevant question to today is how does the TSC payment court case, this is from Colin Hallahan, how does the payment court case impact on the NEC4 engineering and construction contract in relation to the scenario if a contractor does not submit a valuation and the PM issues a nil valuation? Well, the difference with the engineering and construction contract is it doesn't require the contractor to give an invoice. The contractor is now required to make an application. That's a new part for NEC4 that wasn't there previously, and the project manager is obliged, as the PM always was, to consider the application that was made. But the court case we referred to was specifically referring to linking due dates and final dates for payment to an invoice, which isn't the case in the engineering and construction contract. In the event the contractor does not submit what you've called a valuation, which the contract calls an assessment, then the contract covers that very clearly as to the fact that the PM reassesses the amount due at the same amount as last month, if it's indeed a monthly one. Anything to add there, David?
Yeah, I think this was Colin's question, wasn't it?
Yes.
The NEC4 ECC doesn't include, as Patrick quite says, a requirement for invoice. But the reality of life, I think, is for many clients, is that an invoice is required to for the payment systems to work, and therefore seeing a Z clause which introduces the requirement for an invoice is not uncommon for the ECC. Sometimes you might see it just written into the scope, but as often it is a Z clause. So I think if you are using the engineering construction contract, the long form, the NEC4 there, and you're introducing the need for an invoice with a Z clause, you need to look very carefully at the October 2020 amendments and what the comments were made in the case that we mentioned, the Killen case there, to make sure that you don't write a Z clause that potentially conflicts with the issues that we raised in terms of the construction Construction Act. Sorry.
Okay. Just scrolling through the questions and seeing if anything else pops up. If you do have any further questions, then I think now is the time to do them.
There's a question here from Peter. I don't know, did we address that? Peter says, if we're using an existing long-term NEC4 framework that is using ECCs from the previous 2019 amendments, how would we go about use of 2020 amendments to the framework for use in the future? Oh, that's a good question. So you've got a framework that you've put into place that is using the ECC and maybe other forms, and that agreement, the framework was entered into after Jan 19, but before October 2020. That's the thing, what I read, it's correct. And you want to sort of speed up. Well, I guess the answer really is you can do. but it would be for the parties to have to make that agreement and then do so in writing, maybe a variation, supplemental deed of some sort. The ECC, if you're using it with a framework contract, will be used as a work order. So you haven't, and so you might need to make the amendment to the work order rather than the framework contract itself. Does that answer your question, Peter? Hopefully you're still there. If you want to come online, Peter, and just speak on your microphone, please do. If not, he says that makes sense. Thank you. Right.
Excellent. Right. Well, it appears we've run out of questions unless anyone wants to jump in.
Here's one coming through from Judith. Oh, it's a statement rather than a question.
Oh, it's a compliment. Crikey. Get it framed.
Excellent. And thank you to Judith for your engagement as well. I thought what was interesting was the percentage responses we got on the question as to whether people are using X22. It was much higher than I anticipated, but that's good news. I suppose a supplementary question could have been, we didn't really have time or do it today, perhaps those of you online, you could put a quick one in the chat box, is if you are using X22, and it seems like a significant number of people that responded are you doing it with an option C in its unamended form, or have you tinkered with it?
Oh, we have a new question.
We do. I wonder if we'll just see if we get a response to my comment first, and then we'll deal with Peter's question.
Yeah. Please do feel free to either respond verbally or in the chat function.
Mark has 2 live option C X22 contracts. So I suppose Mark, your question is are you using the unamended version, or did you tinker with it at all? Perish the thought, of course, but there you go.
Hi, David. Yeah, they're pretty much unamended. We made one amendment, which is in line with the update that you've just talked us through, so that we can change key dates and completion dates.
Okay.
Prior to that amendment being issued.
Excellent. And so while I have you on, Mark, what I'm interested to know is operating it. Hopefully you're following the contract. Have you found it to be useful and no obstacles in terms of what it says or what it doesn't say?
No, we find it really good, actually. Very, very useful contract, okay. Particularly when you've got a requirement to start really quickly and get the design work underway.
And those changes that we just talked about in October 2020, with introducing the flexibility with the program aspects, obviously you found that was important to include, and I presume you've been moving those dates around in your ECI phase. Yeah, definitely. Yeah. We used to have a Z clause to do the same thing, so it's good that amendment's been made. Yeah. Okay. Excellent. Thanks. That's great, Mark. A few other people coming through with their responses around X22 saying some amended, some not amended, most amended to some degree or other. Should we try and deal with Peter's question now? Let me just reflect on what it says. It's if you have time, a slightly related question. X22, if we're not proceeding into stage 2, how do we close out the contract? Do we still complete? Well, the answer is you do. The procedure essentially is that if we're not proceeding to stage 2, the project manager has to actually give an instruction removing the rest of the work from the scope. And then, of course, at that point, if you're removing effectively the stage 2 work from the scope, then the PM would be in a position where they can then certify completion. that's a short answer to probably a question that begs other points. But I was trying to answer the question without getting sidetracked. Peter, does that give you what you wanted in terms of an answer? Yeah. If you read the clause, Peter, there is a process there. I think that there's some arguments, I'm not sure they're correct at all, but that there's a sense of sort of termination going on, but it doesn't talk about that. And one of the things that you'll be probably aware with is that if you get to the end of stage 1 and you're not proceeding, providing you close the contract down correctly, the client actually is entitled to engage with another contractor to do that work.
Hi, David, Patrick. I'll jump on if you don't mind, if we've got time. Thanks for your answer. That's good. The query we have is we use the 2-stage contract basically to do a pre-design, a basic design, to then go to sanction for our projects. And if the business decides not to sanction it, we just close it down. So you've answered the first part, which is we just remove the stage 2 scope from the contract, and we can certify completion. I guess another query would be, does everything else just follow? So if they've only done design, which isn't then used, and there's no physical work, do we still have we've got a 52-week defect period? Do we still have to wait that 52 weeks to then issue the defect certificate and everything that goes on it, when in reality everyone has just said that project's gone by the by, we're not even going to another contractor, it's just the business's decision to stop?
I think the answer to that is yes, Peter, because when you look at X22, it is a secondary option. So where you have a secondary option, that's, you still have the core clauses and you still have all the other parts of the contract that you need to operate. So yeah, I think the answer is that you do, that you would remove the scope, you would issue a completion certificate, completion of the certified completion of the whole of the works, and if your defects date is 52 weeks after completion, as per contract dated part 1, that's what it will be. I think, yeah, contractually that's got to be the answer.
Yeah, that's fine. Thank you very much. It was good to get that clarification.
Yeah,
I think the one thing you've got to, sorry, Patrick, one thing you've got to watch, Peter, is that don't forget that the payment process for application and assessment of the amount due continues after the certificate of completion has been issued, all the way through at the intervals up until a defects date. So there still be some requirement to manage that part of the contract. Don't just sort of put it in a drawer and leave it and think you're done. I think you're still going to have to manage that until the end.
Yeah, I think that's where we're hoping we could, with removing all that scope and completing without any physical work being done, that you could just curtail the contract at that point. But if the contract doesn't naturally allow that, we'll just have to keep going for the next year.
Patrick, I think you were going to say something on that.
Yes, just Peter, slightly unique situation you and your company find yourself in at the moment. Are you keeping busy?
Yes, very good. Thank you, Patrick.
Are you allowed contractors on site at the moment?
Yeah, we are. We actually haven't stopped throughout the pandemic due to what we do. Obviously, we've had to continue manufacturing, and so yeah, we've continued full throttle throughout, which has been interesting at times.
Excellent. For those of you who haven't a clue what we're talking about, Peter works for a small pharmaceutical company by the name of AstraZeneca at one of their major manufacturing plants, which I've been in and delivered some training for him in the past. And it's another thing you probably don't think about throughout COVID, where most people are thinking, we've got to settle down, we've got to work from home, we've got to do far less. Certainly in the environment Peter finds himself in, like you've just suggested, I think you've probably never been busier.
Indeed, yes,
Oh,
that's very true.
Well done, and keep going. We all need you.
Thank you.
Cheers. Right.
Got a question from Chris there, actually. He says, where in X22 does it allow the employer to omit the stage 2 scope and award such to another contractor? You've embarrassed me a little bit, Chris, because the hard copy of my contract I've got is the Jan 19 version, but I believe it's in X22.5 and the subclause 3, as it would have been then. So if you go and have a look at your copy of your contract, X22.5, you'll see the rules on if the project manager does not issue a notice to proceed to stage 2, and then it ends up with the words, the client may appoint another contractor to complete the stage 2 works. There are two sort of limitations or tests, I suppose, that have to be applied, though, before that entitlement to appoint of the contractor, and they're set out in the clause. So you have to be a little bit careful with it, but that's where it is. I
just pulled my document out there that I've got one that's up to date. So X22.5 subsection 4.
Yeah, it's moved. I think it's moved the clause down, I imagine.
Yeah, that's right.
Okay, good.
Okay,
thank you, Chris.
Well, we seem to be running out of people and questions, and we're approaching the end. So I think we'll wrap up here. So thank you very much for all of you for attending today. As our organisers put on the chat right at the very start, an hour and a half ago, the PowerPoint presentation will be sent to you all, and I think a recording of today will be published at some point in the future. So thank you very much from me, and no doubt David would like to say his thanks as well.
Yeah, thank you to Patrick for kicking us off and butting up with me today, and a particular thanks to all of you that got involved and asked the questions. It's really no fun talking to a screen with no response. So yeah, much appreciated the questions and your engagement with the Vivox polls that we did. Thank you.
Great. Thank you very much, everyone.